Welcome. 2 o'clock on the dot in London. Welcome, Veronique, Alicia, so many names that I recognize. Daniel, thank you so much for joining. I'm just getting everything up and running now. Let me dismiss that. I can see you guys can hear me. I'm going to open up the chat here so you can communicate with me as well. You can hear me and you can see me. Okay. Fabulous. Admitting everyone in. Chat, hello, hi. Um, Hello, everyone. Welcome. Some of you, I think it's afternoon in most of the countries that I'm seeing, but feel free to say hello to each other, to me on the chat. Are we going to give people literally 1 minute? And I'm going to start now. I'm pulling up the presentation, which you can see now. I'm just checking if the mouse is indeed working. It is working. Welcome to another ISDA Mastery series. I've got the chat open here, so I'm not going to miss out on your questions. And we've got a lot to cover for today. So I'm just going to dive right in. So for those of you who are new, welcome again. I just want to say really quickly why we're doing this. Why am I doing this? Why are you here? I hope to learn something new, to hear from me, to absorb some of the energy. We started the ISDA Mastery webinar series I would say probably about 6, 7 months ago. So I try and do a live event at least once a month or 6 to 7 weeks, so that you don't get too bored of me. But we do love sharing our ISDA knowledge, and I think that's why we are here. The problem within the industry is that the ISDA knowledge is not really easily accessible, and I am on the mission. Um, Not only to share the industry knowledge, as you can see on the screen, but also to empower you to become the best at this craft. And it doesn't only mean being the best at this, the master agreement, or really embracing the knowledge, but my mission is to make the industry knowledge more accessible to negotiators from all corners of the world. So whatever you're based, I think we all um, deserve to learn and understand the beauty of not only the agreement but the industry. So it's about regaining that confidence so that you can go back to the industry, because I know some of you have had a break or perhaps are new to the whole ISDA endeavor. But just really the mission is to empower you so you can take ownership of your careers and feel like this agreement, it's built many careers, definitely mine, but feel like this agreement is something that can help you on that path. It's about making the most out of that time and help you access that version of you. That's my mission, that will be sitting comfortably and very confidently in any boardrooms. You can lead the conversations about ISDA and you don't feel like, you're missing out on something or on knowledge that's never been shared before. So this is a very different angle to learning about ISDA Master Agreement and how to position yourself in the industry. So it's more than just about the ISDA Master Agreement. So I'm on the mission to transform your curiosity into impact, and I'm very grateful that you're here with me today. So without further ado, today I thought, and I don't remember who gave me that idea, but they were like, oh my God, editor, can you do a page turn? Because do you know what? Not many negotiators or in the ISDA space had actually read the first 28 and a half or 29 pages of the ISDA line by line. And this is the mission today. It's very ambitious because I received some beautiful questions as well. But this is where we're going. We're going to dive into the world of ISDA. We are going to talk about why we need them. I always kind of like to set the scene and then dive straight into the ISDA structure in 2002 preprint. Don't worry, the first 5 steps are not going to take too long. I really want to give you the value during this session, and we're going to talk about the practical application as well. And obviously then there is time for Q&A. So I've got everyone's details here. I can see the chat. You can hear me. Oh, I can see more people coming in. Hello, everyone. Okay, lovely. I'm gonna ask my team next time to kind of get everyone admitted without me having to do that. But um, for all those of you who are new to the ISDA Master series or not know much about me, My name is Adita, losing the voice here. And I'm educator of big dreams. That's someone called me that the other day, and I thought I'm just going to put it on the slide. But just a quick reintroduction. I'm the founder of a boutique consultancy called Fit Legal. We have a D Lab, so Derivatives Lab, which is our educational platform as well. And I spent over 16 years, it's going to be longer now, in the banking and finance industry. But I was at Man Group's, Credit Suisse, and now obviously I practice what I preach. I teach from experience. Everything that you guys that we're going to be talking about today is what I've learned through years of my experience, but also I do that daily with my clients. So I'm kind of always sharing the up to date knowledge that we've got, the industry knowledge that I think you are here to hear about, and we all should have access to. So welcome again, Planet ISDA. If you've just landed a job as an ISDA negotiator, or congratulations. If you're a seasoned negotiator or you're not even a negotiator, you in credit, um, compliance or trading, it is equally as important to understand these concepts. So I am very excited that you're here. ISDA actually, there's trillions of dollars that this agreement controls, and but in fact it's a small planet. You all get to know each other very quickly, people from across the world, and I would love to actually, I'll tell you more about that towards the end. I would love to connect us all, create a space which is safe, confidential space where we can discuss all sorts of different ISDA and derivatives related issues. It's such an exciting industry, and sometimes, just asking a fellow negotiator how they dealt with certain things, and I learn every day, would be a very useful thing. So watch that space. I'm on a mission to connect us all, maybe through Facebook or some sort of a confidential group. I'll let you know. So, okay, ISDA Master Agreement is the most frequently used agreement in the world of derivatives. It is essentially the only agreement that allows you to trade OTC, and we're going to talk about OTC versus ETD in a minute, but it's a bilateral framework agreement between two parties that governs their relationship of trading over-the-counter derivatives. As I mentioned, the most frequently probably negotiated agreements in the world, and when it comes to banking and finance. And the purpose of it is to really address the biggest fear that the financial markets have, which is the counterparty defaulting on its obligations. So the agreement gives you that certainty, mutual protections, and we know exactly what's going to happen if things do go wrong. So if you don't get to sign the agreement, if you decide to trade without it, which is very rare, it does happen, but it's very rare, you don't have these mutual protections and you're lacking that certainty. It is not only legal certainty, it's business operational certainty, and we all understand what happens and what are the parties' representations, obligations, and agreements when they trade OTC. There is a level of customization allowed through the ISDA, which I'm sure you guys know all very well. That's through the ISDA Schedule. So you can customize your terms. And I get, again, one of those questions came up again for this webinar, which is fantastic. Like, why do we need to do that? So I'll address that very, very soon. But it is a flexible arrangement. So you can really adjust the framework through changing through the schedule, you can change the preprint. And that will allow you then to respond to your internal policies, your credit requirements, and will allow you also to trade multiple transactions under one agreement. So that's very important. It's a single agreement concept. I can see the L is missing on the slide. Single agreement concept is pivotal to the working of the ISDA Master Agreement, because everything can be done under that one framework, as opposed to negotiate legal arrangement every time you want to enter into a transaction. And also netting, very important. Netting enables you management of your day-to-day exposure and settlement. So there is different types of netting under the ISDA. So it's your daytime payment netting, goes settlement netting, but also closeout netting, which is one single, probably most important concept why we have ISDAs in place in the first place. It ensures that the structure, when collapsing, comes down to one single payment from one party to the other, as opposed to 1,500 different payments and then figuring out who owes whom what. So this is the main purpose of the agreement. But we all know, I couldn't resist to put this slide on the why is this important to understand. And I know that the collapse of Lehman was ages ago, but no matter the country where you're sitting in, no matter your function today, your role, however you describe yourself, however you fit into the banking or asset management structure, the regulators have been on the mission globally to address the crisis from 2008 and limit that systemic risk that they keep talking about. And the origin of that goes back to the Lehman collapse. So I always try and mention that because that will give you the understanding. It's what is the reason why they're sharpening their pens, why we need to talk about T0 soon, why these things are happening. This is the reason. There's two main pillars that have been designed really to mitigate the risk of trading OTC. And one is clearing. And number two is asking for more margin quicker. So quicker settlement, asking for margin clearing. All of these mitigation tools are being introduced because is a result of the previous system essentially falling and failing us on so many levels. So this is, I think, quite important to remember in the back of your head when we negotiate this. That's the big reason. So there are different types of derivatives. Before we dive into the 2002 preprint, I do want to mention that because sometimes I hear, oh, at a time, when are we going to, is ETD, because ETD can be covered under ISDA, is there like a clearing module, or previously that's what it was called, or a clearing document? Yes, it all kind of forms part of the wider, you can have cleared derivatives, there's a cleared derivatives exchange agreement, all of that can fit into the ISDA structure, which I'll show you in a minute. But the purpose of today's session is OTC, so over-the-counter derivatives, which are traded directly between two counterparties without the supervision of any exchange. There is no pass-through, there is no third parties being involved, there is no additional party, taking part in this arrangement. So it's bilateral and quite bespoke. And then exchange traded derivatives are those who are transacted on a centralized exchange platform. The documentation for that is very different. It's governed by the FAA. There is usually a futures and options agreement that you have to put in place. So this is not our world that we're going to be discussing today. And I always laugh that there was this analogy that we love that I am very fond of. I don't know if you heard me saying that before. If you did, and apologies, but it's like going to a market and purchasing, various fruits. On the exchange, everything is neatly displayed. You see the prices, you see the fruit. You can buy a pound of apples for $20 or whatever it is. OTC is very different. You don't go to the market with the same people. You call your broker, you order your smoothie or banana mix with coconut, whatever it is that you fancy. That's what OTC enables to do. That's why it's one of the most popular agreements in the world, because it's very bespoke and it allows for that customization. And I think that's one of the main reasons why ISDA is going to be sticking around forever, because it's really one agreement that can be fully customized. And trust me, big names love customization. So big banks and especially asset managers, they really like something that is unique, specially designed for them, and where the terms are reflective of their culture, of the statute they have and reputation. So that's why they love negotiating and customizing the agreement. Now, the structure, you're probably familiar with that already. We've got the preprint, which we're going to talk about today, and there is the schedule. So the negotiation is on the back of the schedule. Is the preprint is not negotiated, and that is essentially the architecture of the main ISDA Master Agreement. But obviously, the documentational structure is much bigger. And I'm showing this on the screen now. You've seen that before from me. I like this slide because it just gives you the the magnitude of different documents that you can have under the ISDA Master Agreement. But again, today is not the focus on this documentational structure. The focus is on the ISDA preprint. So, and the practical application. I'm actually going to do both at the same time. So grab your espresso or coffee or a drink, whatever you've got. We're gonna whisk through it. It is a lot of text. It's a lot of documentation that covers the first 20 odd pages of this preprint. So I'm obviously going to do it at a high level. But when I was preparing for the session, I'd selected the most valuable points that I think you learn, in-house, and I think most is the negotiators who never read the preprint, which is many of us. I mean, I didn't, I walked into Credit Suisse was given a playbook, and usually the way it works is that no one really sits down with you. And when do you have time in hundreds and thousands of emails that you receive daily to sit down and read the 28 pages of the ISDA preprint? It makes no sense. So to manage your expectations here as well, we'll not be obviously going through the agreement line by line, but I have carefully selected those specific lines of the preprint and those provisions and those sections that have particular practical implications. So you are going to see them in the schedule, essentially. So that's the purpose of the session. Right. Okay, so we are diving right in. ISDA starts with a preamble and section 1. So the first thing that I wanted to mention is you need to remember, obviously, to introduce the parties to the ISDA, but pay attention to the date. The ISDA is dated as of for a reason. It is dated as of to enable you to insert the date there, whereby you can predate essentially the agreement to ensure that the parties who traded prior to the ISDA becoming fully enforced in effect take the benefit and actually are covered by the provisions of the ISDA Master Agreement. This has actually been drafted so on purpose. So you see that the parties have entered, it says in anticipation of entering into agreements or have already entered into certain agreements. The drafting of the preamble is very clear. So it is often, I've actually done that quite a few times, where we would, the trade is imminent, we would negotiate the ISDA very quickly or use the templates that we had at Credit Suisse or Man Group. And then we know the business would have told her we've traded today, but the ISDA is going to be signed. I'm like, I'm not finished yet. I need one more day. The execution is pending. So we would always make sure, I actually had a process within the team as to have we entered into a transaction yet? If we'd entered into a transaction, the ISDA date on the first page must be the date of that transaction, so that we covered for that trade up until its maturity. And if anything happens in relation to that trade, it's covered by the ISDA. Sorry, that took longer than I would expect, but just bear that in mind. It is not, because certain, councils are like, no, it needs to be the date of the signature. No, it doesn't. It is the date where you entered into a transaction. And if you haven't yet, then obviously you can date it as of the date of the signature. What is important is that we introduce the parties, Party A and Party B. It is various banks have different ways of doing it. You'll see some banks doing the whole, this is the entity incorporated in England and Wales with a registered company number, blah, 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 and the registered office address. We don't do that anymore. For majority of our clients, we just say the full legal name. LEI sometimes may be useful, but that's part of the onboarding. What is important there is who is who. If you're the bank, if you're on the sell side, the convention calls for you to be party A. If you're on the buy side, again, the convention calls for you to be party B. There are certain asset managers or corporates that think this is not correct and they should be party A. I've spoken to it briefly at the last session, I remember, and I talk about it with my students a lot. I try and resist that urge. Barclays had actually introduced recently changes to their template when they are party B, which has confused us all. So we kind of when approaching Barclays, the approach is really to ask them to to change it around. At least here in EMEA, that's what we're seeing. But I would always prefer for the bank to be party A. Obviously, if you have two banks, then that's a different issue. Then whoever is using their template is party A. That's the convention. What I wanted to flag here is that ISDA starts with section 1, which have quite a few very important provisions. So we can ignore definitions. It tells you there is 14 different sections, and definitions are covered in section 14. But the hierarchy of the ISDA is explained at the outset. So what this means is that in a closeout situation, obviously, we need to understand, or if there's a conflict rather than closeout, which document prevails, because we've got the preprint, we've got the schedule, and we've got the confirmations. So key thing to remember, confirmations always prevail in respect of a specific trade. Whatever it is that you agree in the confirmation stands. So you may spend, 3 months or 7 weeks negotiating, who the calculation agent is. But if your confirmation says it's the bank, full stop, that's exactly what's going to happen. And that term is going to be applied if there is a conflict or, God forbid, a dispute in relation to that trade. So be mindful of that. Confirmation always supersedes anything else that you agree in respect of that transaction. And then single agreement concept, pivotal obviously to the ISDA. I mentioned that already. The values of all the multiple transactions that we entered into are have the capability of being netted down or netted off, I suppose, against each other to produce a single figure, which is your closeout amount towards the end of the ISDA life. And that is very, very important. We're going to talk about it in the context of bankruptcy in a minute. Now, Section 2 goes on to talk about obligations of the parties. So there is quite a few bits that I picked here. So obviously parties have different obligations towards each other. The first obligation is to pay or deliver. Remember, ISDA also deals with delivery of goods. If you have physical commodities, barrels of oil or aluminium or anything like that, it talks about always payments and deliveries. So your obligation is to pay on a specific date as defined in the confirmation. Section 2A3, I wanted to mention because it has bad rep and it's been somehow flagged as problematic. This section potentially allows the non-defaulting party to withhold or suspend its payments indefinitely if there is a problem situation. So this is not ideal and most likely not what ISDA drafting team had in mind. ISDA had addressed this issue since, and there is some language that they've published to deal with the fact that it is potentially indefinite time during which you can withhold your payments if there is a difficulty under the agreement, such as illegality, force majeure, etc., etc. This language is available on the ISDA website. Is essentially introducing like a long stop date. Market standards around 60 to 90 days. I haven't actually seen this being used a lot by the market participants. They like the vagueness and indefinity, of this provision. Which tells you a lot. Sometimes vagueness can work to your advantage. I am so a big fan of clarity in legal contracts. So you would see that probably most of the templates, like people introducing that 90-day cutoff date. Change of account is also present in the obligations space. I do like to flag this one because in practice, remember, your counterparty can change the account where they receive payments by giving you 5 local business days notice. This is usually amended to make sure that they can do that, provided the account is in the same place of jurisdiction as the original account. Because for tax purposes, imagine if they move from US to UK, even, or from UK to Portugal, it may be a slightly different tax treatment. So we like amending this section. So that's where you'll be looking at it to be. Netting of payments, very important. All of this text in section 2 talks about how payments can be netted. Remember, we have different types of netting in the ISDA Master Agreement. There is the closeout netting, there is settlement netting, which happens on a day-to-day basis. And 2002 version of the ISDA introduces the multiple transaction payment netting. Remember, that is not something that is always operational feasible. Usually I see banks like Goldman, Morgan Stanley applying this to FX trades only, or there is a carve out in this provision. So this is where you amended section 2C. Now, section 2D talks about tax. I'm not a tax lawyer, but you must remember that ISDA Master Agreement is an international agreement. So there is this cross-border transaction interaction, which results in tax implications. And tax authorities may impose taxes, which are called withholding taxes on payments under the ISDA transactions. So there is actually section 2D goes on for half a page and talks about a tax indemnity. So this is where this happens. The ISDA assumption is that a payer has to increase the payments that it makes to you if a withholding of tax is charged, so that you, the receiver of the payment, receive exactly what you're expected to receive. So in this instance, ISDA calls this the indemnifiable tax, because the payee is entitled to be indemnified from it. So that's how it works. Now, this is rarely amended, but what is really, really important, the reason why I'm flagging is because it is important that you give relevant tax documentation, tax representations under Part 3 of the ISDA schedule. So this is why everyone is chasing tax documents before you can launch and enter into ISDA Master Agreement. Next section talks about representation. So here, party represent various matters that are listed in this section 3 to each other. And essentially, the representation, always remember that you're making under the ISDA is that all of this is true and accurate. And also remember that the ISDA preprint requires that these representations, you enter into them every single time a transaction is entered into. So they are repeated. Every single time you enter into a transaction, they are deemed repeated. So these are fairly straightforward, but I like looking at them because two things. You have counterparties and usually banks that try and enhance the basic representations, whilst these ISDA drafts are pretty comprehensive. So always when you're on the buy side, you can try and rebut, why do I need to give additional representations? I'm already telling you, I'm legally organized. I have, I've been incorporated validly in this jurisdiction. I've got applicable licenses. I have the relevant regulatory approvals, and I've got the power to enter into this agreement. So remember, when you negotiate the schedule, this is where it sits. So section 3A, this is the best way to rebut some of these additional reps that banks are usually asking for. The other one that I wanted to mention is the conflicts or actually no litigation, which should show up hopefully on the next page in a minute. This is sometimes amended in the schedule where counterparties like to add affiliates to no conflict or no violation, provision. So they want to try and ensure that these provisions not only capture you as their counterparty, but also your asset manager, if you're a fund, or your affiliates. So be mindful of that. It is probably not something that I would accept. It's very difficult to monitor and not really feasible for the buy side. But I understand why the sell side would want that. So what I would like you to pay extra attention is always the section 3D. So remember, any information that you provide under the ISDA has this very high threshold of being true, accurate, and complete in every material respect. So it is very common that we change that in the ISDA schedule because your auditors do not give you that same representation in respect of your financials. So this is why this section is being amended, and you'll see that's where it sits in 3D. And also section 3 of the ISDA preprint gives you the ability to add representation. So I'd already mentioned that. When it's appropriate, and I had that question the other week, when it's appropriate to amend it is only, in my view, where you have jurisdictional specific representations. So as you know, ISDA would have legal opinions that cover various jurisdictions under which you can take a look on the ISDA website. Obviously, it's a paid service, so not available for ordinary people. But if you do have access, or if your company or organization is a member, you will see that certain jurisdictions would call for different representations. So you can try and include these representations as part of section 3 reps. Banks are becoming more and more notoriously, I would say, I don't want to use the word cheeky because I understand the approach, but they would try and slot representations as events of default, for example, which have a much more, I would say, it is a little bit like, pressing the nuclear button. So representation, claiming breach of rep has got 30 days grace period. There is a process that you need to follow. It's a very different process to, an event of default. And I'm going to talk about it in a minute in more detail. But powering through, because we're only on section 4 and I want to cover what I've prepared. So, and your questions. Section 4. Okay, section 4 is where we talk about furnishing certain information for the purposes of the ISDA Master Agreement, and you confirm that you can maintain authorizations, you comply with certain laws. So this is an agreement to certain things between the parties, and those agreements vary. We have tax-related matters, generic confirmations that parties need to deliver certain information to each other. Some prior to execution of the agreement, others after execution of the agreement, or throughout the life of the relationship. And usually that we're talking here about your licenses, applicable laws and regulations that are required to, tick the boxes for applicable laws and regulations. This is particularly important if you're coming from jurisdictions like South Africa or somewhere in Latin America, where you need to procure certain additional licensing documents. And this is why when I work with clients from these bespoke jurisdictions, we kind of resist anything in addition that the bank may ask, because this comply with laws, section 4 of the preprint already covers it pretty thoroughly. So I always try and resist, because you don't want to submit to additional obligations. They're difficult to monitor. Imagine who, the standard is the preprint is that already thought about these things. So it's an international global agreement. So, unless it's something that there is that not recommends as nice to have, but say it's a must, it's more than just a recommendation, it's an obligation to include. You would see me just requesting that it's removed, essentially. So this section also talks about financial statements. I mentioned that already, and will in terms of practical application, it gives you also an opportunity to include new agreements. So the banks do that. That's often attempted to include new agreements here as well. And again, the more jurisdiction specific, the better if you're a bank, but otherwise I would just resist any amendments to sections 3 and 4. Now, the heart of the ISDA famously is obviously your sections 5 and 6. Failure to pay and deliver, and so many other different events of default are listed here. It's a massive section, if I may use that word. It goes on forever. But what I wanted to spell out is a few things, grace periods, and flag things to you that will prompt your thinking when you negotiate, hopefully. So the obvious one, there's 8 events of default. So quite a lot. So anytime your bank counterparty or I think asset managers rarely ask for additional events of default against counterparties. We ask for termination events, which are slightly different. But when we do, there must be something that is worthy, arguing for. So because the ISDA is quite comprehensive, we've got failure to pay or deliver. So a typical one, your counterparty simply does not do what they promised you they would do. And there's 1 local business day grace period for that. So it already exists. A lot of people forget about it, and then they insert new language to negotiate additional, grace period. Remember that it's already they already exist. And then the typical carve out for errors of operational and administrative nature, it's actually usually applied to cross default, not your standard failure to pay. So this is the distinction that many negotiators don't kind of pick up on. But remember, there is already 1 day grace period. Breach of agreement, essentially either you or your counterparty fails to comply with any agreement or obligation under the ISDA. I have this way of kind of arguing if they ask us for new additional representations or agreements to say, look, guys, you already can claim breach of agreement if you don't comply with it. And the bank is always saying like, but Elsa is going to take us. There is a 30-day grace period to fix the issue. 30 days, we can't do anything. So, I sympathize with it. So we need to find a different solution usually. But this could be your way of negotiating. Breach of agreement, it already exists. If you fail to deliver and comply with any agreement, representation, warranty, obligation under ISDA, there is a process to follow under the 2002 agreement. Remember though, 30-day grace period. Too long, you can amend it in the schedule. Okay, the breach of agreement event of default under 2002 version of the ISDA also covers repudiation these days. So remember about that. This is essentially triggered if your counterparty disaffirms, disclaims, repudiates, so in other words, rejects any part of the contract or challenges its validity. This is not present in the previous version of the agreement. I'm not quite sure of the genesis of it, but someone, within the ISDA squad thought this was missing. So here it is. It's kind of included and embedded within section 5 of breach of agreement. Next are credit support defaults. Remember, ISDA likes credit support documentation. It's mentioned within the preprint. ISDA support documents are credit support agreements, but also letters of credit, any guarantees. So if any of those documents fall short, or if there's a breach under them, essentially, that would constitute an event of default. Next comes misrep, and that one is interesting. Misrepresentation applies to certain breaches of statements that you would make under Section 3, other than tax, because for tax representations, we've got separate tax events, which we'll talk about in a minute. So you are misrepresenting to your counterparty. You've made a statement that's proven to be untrue. You can trigger this event of default if any of these representations that we've just discussed are not true, and you're essentially claiming that you were induced to enter into the agreement where this, materially incorrect or misleading representation was made. Now, why this is interesting is because misrepresentation is the only event of default that does not require grace period. There is none specified under the ISDA. It is considered so striking, probably, for the relationship, and so burdensome on the non-defaulting party, that technically, if you are of a view that your counterparty has misrepresented and the representation turns out not to be true, you can move straight to the world of termination. That is very important because every event of default has got notice periods attached to it, and you really have to kind of work through the process that ISDA tells you. Without serving that notice, nothing happens. You need to wait for the grace period to expire, etc. So misrep is lacking all of that. I have personally never experienced misrepresentation action under the ISDA. I think it needs to be pretty significant, but obviously there is case law around it. But yeah, I found that interesting. There is no grace period there, and I thought I'll mention it. So that's a quirk. Dust, so default under specified transaction. I feel like it's called dust because everything kind of falls into dust when this one is triggered. So it is, in other words, your limited or derivatives cost default provision is also an event of default. It is something that sits in the ISDA schedule. One of the first things you see in the ISDA schedule. Now, ISDA loves anything that is specified. Specified transaction, specified entity. Every time you see that in the context of ISDA Master Agreement, think one outside of this agreement. So specified transaction is the one between you and your counterparty, but not covered by this specific agreement. Specified entity is one that is, connected to you or your counterparty, but not within the ISDA Master Agreement. I hope that makes sense. But essentially, it's the transaction outside of the ISDA between the parties to the ISDA. So think of trading agreements that you have with your counterparty, like repo or other swap arrangements, or some stock lending, for example. The practical application here is that sometimes it is requested that we amend this. So obviously, any failure to pay or failure to deliver under those other specified transactions would have the capability of collapsing your own ISDA Master Agreement. So this requires for your non-defaulting party to close out the whole agreement, not just the specified transaction itself. Sorry, it actually doesn't. It could be only one transaction, but that's the most common amendment. So the common amendments to dust under the schedule would change what specified transaction is. The banks would want to make it as big and as wide as possible, or definition. The buy side would resist and start deleting and make it a very small, because essentially, why would you want the list of sinister scenarios based on which your counterparty could close out the ISDA to be this long? You want it to be neat and quick and very small, and the threshold should be like unattainable. So that's why the negotiation of these is very, very interesting. And then after this comes cross default, which is triggered on defaults of borrowings with third parties. So Dust is between you and your counterparty outside of the ISDA, and your cross default is where you defaulted or your counterparty on some sort of borrowing or debt. You've got a debt with a third party, and that debt has increased the threshold amount which we agree in the ISDA schedule. So that also is negotiated in the ISDA schedule. You have that practical impact because you need to negotiate not only what is meant by cross default, what is borrowed money or specified indebtedness, but also you need to negotiate the threshold amount. So there is quite a few elements to cross default that need to be negotiated. And remember, both dust and cross default would only apply, especially with cross default, if you select it to apply under the ISDA schedule. So it's an election. It doesn't go in by default. You need to make an election as to whether you wish to apply it or not. The most popular probably amendment to cross default, so again, practical impact on this provision is to upgrade it or downgrade it, some would say, to cross acceleration, depends on which side of the market you're on. So cross acceleration I talked about previously. It is considered a less sensitive trigger. It doesn't require acceleration of rights by the third party creditor. So cross default in this instance would not be able to be triggered at the awareness point. It would have to be that you wait for your counterparty's creditor to accelerate their rights under the other agreement. So that's the main difference. I'm actually seeing some banks changing their templates to cross acceleration, which is easier to monitor, and it is becoming the new market standard in my view. I think that's the way the industry is heading, but I think it will take a cultural shift to change everything to cross acceleration. I'm definitely pro cross acceleration, but I understand there are certain benefits of cross default, but the problem with cross default is quite obvious. How do we know it occurred? There is no way, so you're risking your reputation if you trigger something so sinister without knowing that it actually happened. Next comes bankruptcy. This section goes on for pages, and it comes, ISDA has come up with really every potential synonym of the word bankruptcy, and every permutation of the elements that may constitute bankruptcy have been included. So it's very thoroughly drafted, and if I see any banks or counterparties coming and saying, and bankruptcy should also mean X, Y, and Z, it is not welcome unless the ISDA opinion tells you that in this jurisdiction, ISDA has missed out that word or that word, and these additional provisions should be included. Remember, bankruptcy has a 15-day grace period, during which technically bankruptcy can be dismissed, or stay period has ceased, so something may have been improved. This is sometimes negotiated, but we kind of like the 15 days. It depends on who your counterparty is really, but bankruptcy is pretty. Did I miss one? Sorry, I think there was 8. Merger without assumption. Merger without assumption. Very rarely triggered. I recall once. Yeah, once it occurred. This covers situations where your counterparty, so again, it's an event of default, counterparty or its credit support provider merges or transfers most of its assets or amalgamates with another entity. And essentially, that new entity either does not assume the rights and obligations of the ISDA or does not assume the guarantee, for instance, that was under the ISDA. So in either case, you end up in a weaker position than originally envisaged. That's the purpose of this termination event. Rarely negotiated. I don't see it being in the schedule mentioned a lot. Now, Section 6, I've got 5 termination events with an option of 6 one. And I'm going to tell you briefly what's important here. Illegality only comes to play where it's illegal for your counterparty to perform under the agreement. Now, COVID has changed a lot of this. The understanding of these provisions has definitely had an impact on how we understand these provisions. I do resist any additional changes to illegality. I think it's been drafted quite nicely and neatly. It needs to be a change of law that triggers this. It is essentially illegal for me to enter into any transactions with you. That would require, redrafting of the legislation, derivatives legislation in the country. So we kind of almost always expect illegality. Remember, termination events are less sinister. It's kind of something that happened to you, so it's less within your control. Whilst events of default, someone is to blame. You've done something wrong. So here we're in the termination event and closeout space, and force majeure comes next. And this, on the other hand, covers events that are outside of parties' control. So your act of state, wars, riots, natural disasters, acts of God, you name it, which make the performance for the office under the agreement impossible or impracticable. So ISDA actually uses those words, impossible or impracticable. And some had not liked that because there is a separate legal term of impossibility that can be drawn into the force majeure event, and force majeure was trying to be used during COVID. We've seen this being redrafted multiple times during COVID, and then the ISDA has addressed this separately as well and issued their own language. So you're likely to see some version of force majeure in your ISDA schedule. It depends on the counterparty. I think certain brokers care about it more than the others, but here's the twist. Force majeure event as such is completely undefined under the ISDA. There is no definition of what it means. Yes, I know it's a little bit odd. Instead, ISDA makes a reference to an act of state, and there is some vague guidelines around the force majeure in the ISDA equity definitions. So what is force majeure is not explained. That's why a lot of counterparties kind of are drawn into trying to define this. The problem with that, I think, when I was reading into it, that was intentional. ISDA has not had the need to define it so fully, other than saying it's some sort of an act of state, because you're always risking that you're not going to capture an event such as COVID, for instance, or a terrorist attack of certain nature, God forbid. So there is that risk that by defining what is an act of God, your list is always almost by definition incomplete. So that's why it was left undefined. And since COVID, as I mentioned, there's been multiple attempts to define it, and ISDA's issued their own language. I think it's available actually free of charge. If you Google it, it should come up. So another important thing to know is that ISDA, when drafting this, because force majeure is not included in the 92 agreement, was concerned that both illegality and force majeure happening should not really trigger any immediate reaction of the counterparties, because they're so pivotal, these events, in the change of the economy. It could be something truly dramatic, that the best thing to do was not to react immediately. So what they've done with illegality and force majeure is they've introduced something called waiting periods. So because they thought it would be very good if we just stay and wait and see what's going to happen. Is something actually going to happen? Are the circumstances going to change? Maybe this will be quickly resolved. So waiting periods have been introduced. Yeah, power shortage. I'm seeing that question. Power shortage for 20 hours. Can this be a force majeure? Well, not in my view. That is an operational kind of issue, but power shortage, unless it's like a war related, let's say it's a war situation in your country, you could probably try and put it as a force majeure, but hang on, because 24 hours is going to be resolved within the waiting period. So you probably would get away with it, actually, when I'm thinking about it, because of the waiting periods. You could get away with it as a force majeure if the drafting of it is correct. Wait periods is that breathing space during which the problems could be resolved. And for illegalities, 3 days, business days, and for force majeure is 8 local business days. So that's quite longer. So it's an interesting question. I've not come across. I'll come back to you, JC, on that. That's such a good question. I think you could get away with it as a force majeure if you don't pay. And also 24 hours is also grace period for non-payment, so not much would happen. A power shortage would be a bigger problem if it's more than the waiting period, for instance, of 8 days, right? Then we've got a situation. That's why you've got that waiting period. Pro tip here again, practical application. If you're looking for those periods in the ISDA preprint, that's we're looking at, you're not going to find them. It's buried in the definitions of the waiting period. So if you want to amend them, you need to amend the definition, not section 6. That's where the waiting periods are hidden. And then there was a couple of tax events, which again, I mean, it may happen where there is a change of tax law in your jurisdiction. It does happen. And as a result, you'll be burdened by paying extra tax or not receiving enough tax. And if there is a credit event upon merger as well, that is also something that would result in a tax disadvantage. That's more tax event upon merger, sorry, but then credit event upon merger where you are or your counterparty is merging with an entity that is materially weaker as a result, and that puts you in a disadvantaged position. A little quirk there. There is only one place in the preprint where ISDA introduces a new terminology. The affected party is one that has initiated the merger, that's in respect of the tax event upon merger, but the one who suffers the consequences of that tax event upon merger is called the burdened party. That's the only one place in the ISDA preprint where the burdened party terminology is used in case you ever need to find it and someone is fiddling with the definitions. So these are, and credit event upon merger, as mentioned, there is a number of events. You may come across that actually in the ISDA schedule. Credit event merger needs to be applied in the schedule if you want to apply it, but also there is lots of attempts to define what is materially weaker. So the entity that is the surviving entity, as we call it, must be material weaker, and it's not been explained in the ISDA as to what is material weaker. So you can either define it, and some attempt to define it by essentially including credit ratings, for example, or adding some additional language to holdings of the company. So there is various options. This is actually something that may come up in your negotiations. I would love to flag it. So we're approaching to an end, so I'm going to whisk through it because I do want to answer your questions. There is section on transfers, which is section 7, which does not allow you to transfer the agreement or any of its obligations without consent. There is exemptions to it, so which relate to tax and some other exceptions where the merger has occurred, but generally that's the stance of the ISDA. Section 8 talks about the contractual currency. All payments under the ISDA in the normal course of business must be made in a contractual currency as agreed in a confirmation. There was an indemnity actually in this section 8, but it's only to help you with any judgments post ISDA termination to make sure that the contractual currency is being upheld. Then section 9 talks about a number of different boilerplates. There is entire agreements, survival, remedies, no waiver of rights, headings. So your typical boilerplates. What you see is what you get. These are rarely negotiated, but we do add on to them. Sometimes you'll see severability, for example, or third-party contractual rights under English law ISDAs. I actually really enjoy looking at boilerplates in commercial contracts, whether it's ISDA or not. I think there is always something hidden in the details, and actually we've got a whole module or container for those in the Art of Negotiation training that we're going to be doing soon. So if you're interested in commercial contract negotiations, that's where I kind of look at them. But these would not be normally negotiated or mentioned in the schedule, but we do add to them. Offices, remember, pay attention who is your counterparty, whether they can act through branches. If they can act through branches, then you need to make sure that the branches are not in the countries that are not covered by legal opinions. And remember, a deal with a branch is a deal with a head office if you apply Section 10A if you're a bank. Expenses is also covered. This is just to really confirm that defaulting party is liable for any reasonable out-of-pocket expenses. That's legal fees, stamp duties, any other execution fees. If they were trying to protect their rights under the ISDA and enforce their rights, that's where it will be covered. Never seen this being amended, but it sits there in the ISDA. So we already covered in case anyone is asking you to indemnify them for expenses. Section 12 is actually quite important. It talks about notices. It allows you to use various forms of communication with your counterparty, hand delivery, fax, registered mail, electronic messaging system. All of them are mentioned there. The burden of proof, remember, is on the sender. And remember that there's also now issued new language post-COVID to allow email for Section 5 and 6 notices. So all these sinister events, events of default, termination events, can now be delivered by email if you apply the new language that is issued. In the standard non-amended form, giving notices to Section 5 or 6 via email is prohibited. So it's not allowed. So there is that prohibition for the use of emails unless you amend it. I've not seen many counterparties using this language. Actually, no, BNP, some of the French banks I've seen incorporated the language. I am still steering away from Section 5 and 6 notices being given by email. It is pretty instantaneous. So you want to make sure that the correct email addresses are used if that's your desire. But most of our clients, most counterparties don't still want email to be used for Section 5 and 6. And governing law and jurisdiction, English law and New York law. Remember, jurisdiction is not governing law. There are two different concepts. So in theory, you can have English law govern ISDA and the Swiss courts having the jurisdiction over it. I would obviously advise against this, but that's a possibility. ISDA has been drafted to cater for English law and New York law, and it allows for non-exclusive jurisdiction. This is often amended. So in the schedule, you would see we will have exclusive jurisdiction of either English courts or New York law. And then obviously what we usually amend is in US ISDA's waiver of jury trial, for example. That also is quite a popular amendment. And then Section 14 contains lots of different definitions which feed into the preprint. So nothing out of extraordinary there. I've already mentioned the quirks. Remember, you're not going to find force majeure there, or you're not going to find calculation agent in there either. Calculation agent actually is not mentioned at all in the ISDA preprint. It is mentioned in the closeout amount, but it's not defined in the ISDA preprint at all. You will have to look for it in the equity definitions because it's not there in the ISDA. Completely missed out. Okay, that's a wrap. I mean, I whisked through it, but I hope you got some value and some of the key preprint things I've selected. I had a lot of questions, so thank you so much. I promise you I'm going to email you my responses to all of the questions that I've not seen, but I've selected a few that are, I think, representative and you may find interesting. And for those of you who have to go rush to another meeting, please don't worry. I'm going to send you the replay of this webinar so that you get to hear the answers. And if you wish to email me as well, please feel free to do so. Now, this is interesting, how the shift to T+1 in the US affected the ISDA documentation in the industry and how the upcoming EU shift will affect the documentation and trading practice. There was a lot of other details to that question, and thank you so much for asking this. This entire shift, the US, Canada, Mexico, Argentina have migrated to join India and China to T+1. Has really impacted the industry on multiple levels. And there is a time lag that the industry is struggling with. Yes, Trade Hat, of course, yeah, we'll share the recording. For Section 10A, sorry, why would a counterpart negotiating institute is applied in a schedule? Because not every counterparty would have a multi-branch. This only applies to multi-branch counterparties. So those who have offices in different places, they want to either make sure that if I act through a branch, it will be treated as an office or not. So that's the question really for the sell side, not the buy side. I'll email you a response, Kenneth, as well. And Trish, of course, we'll send you the recording. Any more questions, pop them here. We're going to keep the stream live so then I can see the questions and I'll send you the answers. But going back to this really big migration, I think I'm expecting, firstly, this settlement acceleration trend to continue. It's becoming a global, remember when we looked at this Lehman slide, it's becoming a global priority for regulators. They're sharpening the pens around that. Because if we reduce the settlement risk time frame, we're reducing risk. And trading in derivatives is a risky endeavor. So it is a legalized form of gambling to a certain extent. So the regulators want to make sure that the money arrives as soon as that the obligations of the parties are met as soon as possible. So because it's growing global priority across the globe, I'm expecting that trading practice will be shifting across the continent. So this is not the first time we've actually had the settlement cycle being shortened, and switching has happened in 2014, I think. Or 2013 for Europe. But in this particular instance, we have lost a day which has been a very useful buffer between especially US and Europe, um, where settlement mismatches could have been fixed, where timely funding could have been made, where we could have prevented settlement failure. That extra buffer of 1 day, of 24 hours overnight, has disappeared. So Europe has already got a very low settlement fail, lower than US, at least from my research. But the policymakers seeing this as a real catalyst now to further harmonization. And the reason for a little bit of background there is because not everyone of you may be familiar with the change and that shift, but it's had a tremendous impact on the industry since this announcement, since May, and etc. And also under SEC rules, securities transaction must be affirmed by 9 p.m., which has driven the industry to the same day affirmation, essentially standard across the globe. So this, when it comes to the documentation impact, I may actually do a separate video on this. It's so interesting. We worked with many providers on this change currently, and I've got a lot of clients asking for this. But within the ISDA framework, so for lawyers solely, when we're looking at that shift, it is not actually the ISDA schedule that is most impacted. It will be your trade confirmations. They must reflect correct settlement timelines. And what we're seeing is essentially digging out, your MCAs and seeing what you previously agreed to, issuing umbrella type of amendments to make sure that your execution terms and operational setup are on the same day as trade execution. So you are going to have to go through that exercise if you haven't already, and see if your master confirmations are essentially fit for purpose, if they reflect and align in your practice. There are updates to collateral arrangements that we're seeing as well, that just to reflect the timing mismatch, just ensuring that the collateral timings parties can accommodate. I'm seeing amendments to settlement day definition under the CSAs in both US and the UK. We're seeing there is this language that was very popular by European banks, especially like Deutsche Bank, Barclays, sometimes BNP, that the US banks would just completely not even entertain for a second. And the language said, as long as the transfer is initiated on the same day that the margin was called for, you're fine under the regs. This language is no longer acceptable to banks like Bank of America or majority of our US counterparties. So the EMIR side of things, the European side of things, was a little bit more, I would say, generous with timing there for variation margin purposes. They said something along the lines, as long as you initiate well, that was the interpretation, as long as you initiate the transfer on the day, then, it can arrive and settle on the next day. So that is being also reviewed. But just to wrap up on that, I'm mindful of time. It's a massive operational shift. So legal is just, I would say, 20% of the equation. It's an operational shift. So our clients are looking at solutions like pre-funding arrangements. Many firms are already integrating collateral management systems just to adjust that real time to the new settlement cycles. There's a lot more on that topic. And I'm going to get in touch if you want to know a little bit more about this, but I think we're going to do like a video on that topic, because it's been definitely very popular. And thank you so much for the question. How do we have to negotiate? I think I kind of answered to a certain extent, but this question keeps coming up. Pre-2008, no. But I think because I alluded at the outset that there is this notion of ISDA being skewed towards the sell side, and that is very much the truth. So I think it is really, really pivotal that we give the buy side a chance, and it's a little bit more balanced up. And now we're in a better negotiation position on the buy side for sure. But also big names like Man Group, PIMCOs, your ANGs, big and Investec, big asset managers love customization. These are our clients would come to us with the need for their documents to reflect the practice of their internal, credit, business, trading, operational terms. It is not what ISDA allows. Without customizing it, without negotiating, you're not going to have that ability. So I think it's very important also to make sure that you have the terms that your clients deserve. And that is something that a lot of traders always forget. Like, can we trade now? Can we trade now? the actual underlying issue there is that you are looking after assets of pension funds, for example. There is that expectation from your underlying client that you will, negotiate the terms to the best of your ability to make sure that your client's assets are protected. But yeah, I may do a short film on that as well, because that question always comes up a lot. There was another question which I wanted to address, and I'm going to have to wrap up very soon, but any new provisions, trends, essentially what's being negotiated, included recently. So essentially what's trending. So I chose that question because it's what's trending and is then what's not. The templates are being revised by counterparties for sure. I'm seeing European counterparties being very strict lately on AML and sanctions provisions. We're seeing language to that effect showing up in the ISDA schedules that is being negotiated. I'm seeing attempts to create new and come up with new events of default as opposed to new representations on warranties. Counterparties come up with new events of default, which is not welcome by the buy side, but very inventive on the sell side, I have to admit. And I think there is that shift to cross acceleration. Lots of changes to CSAs because of T+0, as we discussed. So there is, that need to change the settlement cycle definition. And then also outside of the ISDA, I think GIMSLA is having a comeback courtesy of initial margin rules, regulations, and there is a lot of repo type of transactions coming through. So watch that space if you're more than just ISDA. I know some of you want to discuss other contracts as well. So that's the latest probably on my side. And I wanted to mention before we go, please type in your questions that that I'm going to launch another ISDA Lab live experience. If you feel this is going to be slightly different, it's just 4 sessions with me. If you feel the pull to join me live in this experience, let me know and I'll send you the details. But otherwise, I just wanted to express my gratitude to all of you for joining me, staying a bit longer, wanting to learn about ISDA a little bit more. I always learn from you when you ask your questions, so please keep them coming, and look out for another session. I think maybe next time we're going to do collateral agreements. I'm getting a lot of questions from you guys on collateral. For weather derivatives, when negotiating ISDAs, what's the common clauses that are negotiated? Oh, I love that question. There was changes to specified transactions. There was changes to definitions that would capture weather derivatives. I'll send you some stuff on that, Kenneth, because I think it's a very interesting question. But also there is credit default is captured slightly differently. So there is quite a few tweaks that you can make if you're negotiating. Are you negotiating from the buy side or sell side perspective? Just let me know that, and then I'll send you the details. And for all of you other participants and whoever is watching the replay as well, connect with me on social media if you feel like you want to work with me, or buy and sell side. Yeah, no problem. I decide, no problem. Okay, cool. Then you know where to find me. You've got my we're on social media, LinkedIn. I manage that myself. Some of our social media accounts are managed by a wider team, so bear with me if we're not responding, but I always do that myself and make sure that I attend to all of your questions. Thank you so much, and thank you for your thanks. It makes me feel like we're sharing something very valuable, and I think that is yeah, part of the mission, sharing that industry know-how. So yeah, happy negotiating, everyone. Stay tuned and connect with me on social media. And again, if you want more details about any of other initiatives, thank you, Alan. Please ping me send me a DM on Instagram. Or Instagram as well. Derivatives Lab is on Instagram, and I'm on LinkedIn, and so are all of our companies. So thank you again for your time. Look out for another session. Have a fabulous weekend. Thank you.